The final source of the law that we'll look at is general principles of law and equity. Now, these general principles are principles of the law that are recognized by most nations. And when I say most nations, for years that has been construed to mean most Western nations. So general principles of the law are those principles that most Western nations recognize as being fundamental legal principles. And general principles of the law come into play in a courtroom setting or in an arbitration setting. They come there when a court or an arbitrator is looking to fill in a gap where there is no binding international law, where there's no treaty in effect, or no particular custom in effect. The arbitrator or the judge can go out and look to see what is a general principle of the law that should be applicable in this situation. Even though there's no official treaty article, there's no custom on point, we can actually look at, well, what's a general principle of the law? So general principles are often used as gap fillers. Now, what are these gap fillers? General principles, when we discuss general principles, often have to do with fundamental human rights, general principles of human rights. So what are these human rights that we're talking about? Well, first of all, property rights. Property has long been an important value in the West. One might say that Western legal principles are based on the notion of private property and respect for private property. That's a concept that dominates Western legal thought. There's not a lot of historical context for this notion of private property, but it's huge in Western legal thoughts. If you remember back the first draft of the American Declaration of Independence, when citing the inalienable human rights, these were life, liberty, and property. So property has long been a very valued right in Western legal systems. Property rights. The law that protects property rights is thought to be a general principle of the law. Another general principle of the law would be religious rights. And again, this applies to much of Western legal thought, the belief that a person should be private in his own religious affairs and that the state should not interfere with that person's religious thought. So religious affairs or religious rights are held to be general principles of law applicable even in a situation where there's no exact law on point. Another fundamental human right, another general principle would be the right to privacy. The right to privacy. You know, the United States Constitution doesn't include a separate right of privacy. However, many scholars would argue that the right of privacy is inherent in the other rights that are enumerated in the Constitution. For instance, the First Amendment. The First Amendment, which guarantees freedom of speech, freedom of assembly, freedom of religion. Well, what do those things share? Essentially, they share your own private thoughts, and that you should be entitled to your own private thoughts. The Third Amendment, having to do with quartering soldiers in your home. Well, obviously, you have a right to be free of having government interference in your home. So it's really a privacy right. The Fourth Amendment about unreasonable search and seizure, protecting your privacy. So clearly, privacy rights were important to the Founding Fathers, the drafters of the American Constitution, even though they were not specifically enumerated as such. Legal rights, specifically the right to lawyer-client privilege, lawyer-client confidentiality. The confidentiality between a lawyer and his client is one of the most universally respected legal rights, that I should be free to talk to my lawyer and he should be free to give me his advice without worrying about the state or another party discovering the substance of those communications. So legal rights, specifically lawyer-client privilege, are very important and are considered to be general principles of the law. Due process. Due process is a Anglo-American concept. Due process means essentially that there should be a set of rules and the state should follow them. Now, the rules don't have to be fair, the rules don't have to be right, but there should be a set of rules and they should be applied. Now, in the United States today, and in England as well, when we talk about due process, we're generally talking about two aspects. And the first is notice. When someone has a claim against us, whether that entity is a state or whether it is another party, well, you have a right to notice of that claim. You have a right to be notified of the claim. In criminal law, a grand jury will often issue what's called an indictment. And an indictment against a criminal defendant is formal notice of the alleged violation of the law. In the civil context, when you file a lawsuit, it's not enough that you file a lawsuit against someone. You have to give that person formal notice. You have to serve that person with process. That is notice. So the first aspect of due process is notice. The second aspect of due process is an opportunity to be heard, an opportunity to tell your side of the story. These two things must be present in order to satisfy due process requirements. Notice and an opportunity to be heard. And due process has increasingly been considered a general principle of the law that should be applied on an international basis. Non-retroactivity, that's another aspect of the law which says we shouldn't go back in time with laws. Laws should only be prospective in their circumscriptions, meaning we shouldn't go back and be able to make something against the law when that act, when it was committed, was legal. So non-retroactivity of the law, meaning the law should not go back in time, the law should work prospectively into the future. And finally, legal review. This is essentially what we're talking about here is a right to appeal, that there should be some right of appeal over a legal decision, whether that appeal is to a criminal court or in a civil case. One should have the right to appeal. Absent the right to appeal, then we are absent a general principle of the law. That's it for general principles.